Hello folks, welcome to the Edupedia world, and I am Abhinay Gupta. Today we'll continue with the topic, the Banking Regulation Act 1949. So in our previous lecture we had dealt with section 35A, 35B and section 36. In 35A we had seen the powers of the Reserve Bank of India to issue direction to any banking company. In 35B we had seen that no provisions would be amended without the prior approval of the Reserve Bank of India, and the provisions related to the appointment, reappointment, termination, remuneration of the directors or the maximum number of directors and such, right? And even a memorandum, article, resolution, agreement, nothing would stand. For anything that you pass, but in prior to that you would have to have an approval from the Reserve Bank of India, right? And then we had also seen section 36. Right, in section 36 we had dealt with certain other powers of RBI, right? That is to prohibit the certain transactions, assist in amalgamation, giving out loans or advances, right? Or asking them to hold a meeting to discuss any matter, asking any of their officer to discuss a matter with the officer of RBI and like come to a solution of it, right? Or could also ask one of its officer to attend the meeting of the banking company, and it would also be given the opportunity of being heard, and the report should be submitted to the Reserve Bank of India, right? So these were various sections that we had covered in the previous lecture. We'll move ahead with continuing section 36, actually the basic parts of it, 36A, A, B, AE and stuff, right? So let us start the lecture for the day. So the first section that we'll cover up today is Section 36AA, removal of the managerial person. So, first of all, we need to see that what is the need of removing a managerial person. A managerial person is like the top level management of the company, right? So, when does the need arise that you need to remove the manager of the company? Being a chairman, director, chief executive officer, manager, or anything, or any name that you give to that person, he is basically the head of the department, the head of the company, right? So the steps, first is you'll have to record the removal in writing. But the point is, why do you remove, right? It could be done in the interest of the public, interest of the banking company itself, interest of the depositor, or to secure proper management of the company, right? We have seen these four conditions in the previous section also, right? But over here we go back to the same section, and over here in that section what we had seen is that in those situations RBI assists the company to amend the faults done or to get towards proper management, right? CG used to assist the company, but in case where that assistance is not enough, right, or where there is a fault with the managerial person, or the main cause behind that action is the managerial person, it is his fault due to which the company is not able to secure proper management, or the company's act is being performed which is detrimental to the interest of the public or the depositor or the banking company, right? So now the only remedy that is left is to remove that managerial person, right? So this is why we need to remove a managerial person. This is what condition give rise to the situation where we need to remove a managerial person, right? Now we need to see the steps. The first thing, as we see on the screen, is to record the reason in writing. Okay, that will be done, and the reason that we have already discussed, that will be recorded in writing, that okay, this is the proper reason why we need to remove that manager, and that is the only step remaining with the bank, right? Because if there was any assistance that was needed, that has already been applied in the previous section, right? So once first thing is you will record the reason for removal in writing. Then you will give that managerial person an opportunity of being heard, right? You need to understand if there is some other misconception, if there is a misunderstanding going on, right? You need to clear it out. But if it is final that okay, after getting the representation from that person, also if RBI decides that he needs to be removed, he is at fault, then he will be removed, right? But this opportunity of being heard is basically given to remove the chance of any error or misunderstanding, right? Because if everything is going right and still there is something that makes RBI to believe that it is the fault of the manager and stuff, and the manager is being given a chance, an opportunity of being heard, and he proves that it is not due to his negligence or his fault, right? Then that time the RBI may reverse its order. Right? That is why basically an opportunity of being heard is given, right? So that once and all the matter is closed. If he is not able to prove that he is not at fault, he will be considered to be at fault and removed from the office, right? And then the removal process starts. He is removed from office, and then RBI appoints a new manager or the new CEO, and the banking company appoints them, and again the flow continues as it is, right? So these are the basic steps. Record the reason in writing, like give him a reason, give him an opportunity of being heard, then decide, remove him and appoint a new, and continue the business of the banking company, right? Now, if at any point of time you consider that the order of RBI is laying some hardship on the manager, on the CEO, right? Like it is not a correct decision, or even when he was given the opportunity of being heard, he is not able to prove, but still his point is valid, right? Then there has to be some remedy with the managerial person too, right? So what can the managerial person do? He can apply to the central government, right? And this can be done within 30 days, from 13 days from receiving the order for removal, right? When RBI orders him to vacate the office, he has 30 days in hand to apply or to send an application to the central government, right? And whatever the central government decides based on that application and based on the hearing of the points or the reason that was recorded in writing earlier by RBI, the CG will decide whether or not to remove that managerial person, and whatever the central government decides will be the final, right? And now if central government decides that okay, maybe there was a misunderstanding or any thing going on, and CG may set aside the order of removal, and then the managerial person would continue. But if after an application to CG also decides that no, the managerial person is at fault and he needs to be removed, then the consequences are even more critical for the manager or for the CEO or the director, whosoever it is, whatever name you give to that person. The situation worsens up for him, right? Because once it is confirmed by CG that the person is to be removed, then that person cannot hold such office for the next 5 years, right? There is no chance of reappointment for the next 5 years, and if he continues office for any single day, he will have to pay a fine of rupees 250 per day of his continuance, right? So if he is not 100% sure, he should not be making an application to the central government, because the consequence can be even worse, right? And this section 36A have been asked in your examination in recent years, right? In 2010 and 2012 also. So it continues to be important for your further examinations too, right? It is not a very unimportant topic. You can have case studies based on this. RBI has given this, what else should be done, right? What is the remedy with that person? What if CG also removes? What happens, right? These are the type of questions that could be put forward from this section, right? Moving ahead, we have section 36AB, right, where we talk about the additional director appointed by the Reserve Bank of India. So whenever CG finds it necessary to do so, like in RBI's opinion, if it is necessary to do so, he may order in writing to appoint either one or even more than one, if needed, additional directors, right, into the board of the company. That is the discretion of the CG, and that depends on what CG has formed an opinion about. And as per the requirement, there can be one additional director or even more than one additional director. He'll be appointed by CG, and that appointment will be given by RBI, and that appointment will be given by RBI in writing to the banking company, right? So what will be the terms and condition for appointment of this additional director? Right? You have a person incoming into your board. Will all your provisions of the act that applies to the normal director of the company, will those provisions be equally applicable to the additional director? The answer is no, right? So let us see what are the differences and what are the terms and conditions that apply and that do not apply on the additional director of the company, right? So And one more thing, this additional director that the Reserve Bank of India appoints, they will be appointed for a period of 3 years at max, right? The text says that the person will hold office at the pleasure of RBI, like as long as RBI considers it fit for that person to remain in the company, that person will remain in the company. But that period cannot exceed more than 3 years, right? And if further after 3 years RBI wants that person to continue, that person will be reappointed, right, for another period of 3 years, and then another 3 years and another 3 years. So at a block of 3 years at a time, the person will be appointed. Then blocks can be continued for a number of times that RBI deems fit, right? So we have seen what are the conditions and how is an additional director appointed by RBI, right, and the tenure and stuff. Now there are some basic exemptions that are given to the additional director, right, which distinguishes this additional director from the other directors into the board, right? So what are those exemptions? The number one being that this additional director needs no qualification share. We know that qualification share are the basic minimum number of shares that any director will have to acquire, right? That is what makes him also a member of the company. But an additional director need not compulsorily be a member of the company, right? So there is no necessity of buying a minimum number of shares from the company, right? Then the second exemption given to an additional director is that he has no obligation if he acted upon in good faith, which means to say that if the company has attempted to do an act, right, and which is detrimental to the interest of the public or the depositors or the banking company or anything, right, to be precise, the act is inappropriate, right? But if this director is not involved in committing that act, this additional director will not be liable and will not have any obligation towards that act just because he's a director, right? Because other directors, it's the decision of the board, all the directors are equally liable, but additional director have a separate place, right? If they don't agree with that, if they are not into it, they are not liable. But if they are also into it, they'll obviously be liable for that, right? And second, if they are into it, they are supporting the decisions of the board, the board members, but they are acting upon in good faith because they have come new to the company. They don't know a lot of detail about the company. So in good faith, they thought, okay, this action would be useful for the company, right? So they may go ahead with it. But if they're acting in good faith and still there comes out a problem, the additional director will be spared. Right? They will not be held liable and they will have no obligation towards the act that has been performed, right? And thirdly, these additional directors will not be counted in the total number of directors of the company, right? If you have an additional director, like for example, instance, if you take that, say there's a bank X, right? So that X bank has already reached the maximum number of directors allowed to a banking company. And now if RBI wants to elect an additional director, he won't be able to, because already the company is at its ceiling, right? So for that purpose, additional directors are not counted in the total number. So even if including the 2 or 3 additional directors, the total number exceeds the maximum limit, there will be no problem with that because additional directors are not considered or not counted in the total number of directors, right? Even this section, entire list of section 36, 36A, A, B, AE, AG, whatever you take, are important from your exam point of view, right? Because you can have case studies based on these questions. Appointed a director for 4 years. Is it right? No, it's not. If you want to appoint him for 4 years, appoint him for 3 years and then again reappoint him for the next 3 years or next 1 year at the pleasure of the Reserve Bank of India, right? And you have recently been asked question in your 2010 and 2011 examinations. So this topic continues to be important for your further examinations too, right? Then we move on to the next section, that is section 36AE, where the CG acquires the undertaking of the bank. Now when you talk about undertaking, you talk about all the assets, all the liabilities, you talk about the entire company, entire bank, right? Now we need to understand when does CG acquire the undertaking, what are the circumstances that lead CG to acquire the undertaking, and what are the consequences of acquiring the entire undertaking of a bank, right? So for this purpose, if we look back to section 35, the section of inspection, there we had seen that the inspection is conducted by RBI either suo motu or on recommendation of CG. Right? So if the recommendation was made by CG, then they also have to send a report of investigation of inspection to the central government as well. Right? So considering that report, if the central government is of the opinion, right, that the company, that the bank is not performing appropriately, or the actions or the transactions or the performance are detrimental to the interest of the public, to the interest of the depositor, the banking company, right, or they're not able to secure proper management or anything like that, or for better provision of the credit or something, the CG may plan to acquire the undertaking of the bank. Right? When it sees that, yeah, there has been more than one instances, right, where the bank has failed to comply with the directions given to it. So if the bank is not able to comply with the direction, if they are not able to perform, CG will have to take that responsibility in its hand, right, to secure proper management, right, or for better provisioning of credit generally, or credit at particular to any section or any community or anything, or for the interest of the public, interest of depositor, CG may acquire the undertaking of the bank, right? So here we have seen the condition of acquisition, right? Now we need to see, now once the central government has decided to acquire the undertaking of any banking company, then they will have to give an opportunity of being heard, an opportunity to show cause as to why shouldn't I overtake your company? Why shouldn't I acquire all of your undertaking and secure the management? Right? So they'll be given a chance, and then the company, if it can prove that okay, these are the reasons why you should not be undertaking, and we will be able to do what you are planning and we'll be abiding by your directions, CG may step back, right? But if they're not able to prove their worth, CG may acquire the undertaking, right? And then once the central government decides to take over the entire undertaking of the bank, then all the assets and liability, right, would vest on the central government from the appointed date, right? And this appointed date will be decided by the central government, because when they are acquiring the undertaking, they have the condition, they'll send them a notice, okay, we'll be acquiring undertaking. So with that, they will also give them the date, the appointed date from which they will be acquiring the undertaking. So from that particular date, all the assets and all the liabilities will vest on the central government, right? And then what about the suits and the proceedings that are carried forward or that are continuing in the name of the banking company? So those suits and proceedings would continue, but not in the name of the banking company. Now they would be continued in the name of the central government, right? So they would be continued, prosecuted, or enforced by or against the central government now, right? The company has no role to play with that. So with that, we come to an end of this lecture. Stay tuned for the next lecture. We have very limited sections remaining with this chapter. I hope the chapter has been clear with you guys. If you have any queries, please look back to the previous lectures, previous slides. Every section have been explained in detail, right? If you look at the starting of each lecture, you will be able to revise the sections that we have covered. That is for memorizing purpose, right? So until the next class, this is Abhinay Gupta signing off. Thank you.